Hi, today I'm speaking with Christina from Duke, George, and we're going to cover off the issues as they relate to family violence charges and orders. Christina, welcome.
Thank you very much for having me.
Can you give us a short explanation of this family violence situation and how it compares and or contrasts to just regular orders for protection?
Certainly. So there are two sides to intervention order matters. Firstly, there's the person who feels they need the protection from an order, and they're often called the affected person or the AFM, which is the affected family member. And the second part is the person against whom the order is made. There are two types of orders that can be applied for. One is called a family violence intervention order, and that's for people that are related to each other. So it could be husband or wife, brother or sister, partners, ex-partners, and relationships of that nature. There are other types of orders called personal safety intervention orders, and they relate to relationships such as neighbours or work colleagues. Today we're going to focus, however, on family violence intervention orders.
Right. Okay, so family violence intervention orders. My understanding is there's kind of two sides to this equation, Christina. One is the person who's looking and seeking the protection, or they're fearful or anxious, and the other one, of course, is somebody who the order has been served upon, the recipient of the order. So
that's exactly right.
Pick which either one of those you want to talk about first, and what is the steps and the procedures down both of those tacks, or what should we be doing?
Sure. I'll start with the person who feels they need the protection, so the person applying for the order.
Yep.
Now, intervention orders can arise in a couple of ways. Firstly, there could be a situation where there is an incident occurring and the police are called and they attend at a house and they come upon a fight between two people. Let's use the example of a husband and wife. Mm-hmm. The police might decide just on their own accord that the wife, for instance, needs protection from the husband and an intervention order is necessary to protect her. So they could say to the wife, look, we think you should go down and get an intervention order, but in the meantime, we think that you need protection as of right now. So the police have the power to put in place an interim order to protect that person. What then happens is the person against whom the order is made, they get given a notice which says that they have to attend at court for a court hearing. So then the matter goes to court, and the person against whom the order is made can either agree to have an order made against them, or they can disagree to have an order made against them. So if they agree, it means that they agree to abide by certain conditions which the court considers appropriate for how those two people will interact in the future for that period of time. So the court might say, we think that it's appropriate that you have no contact whatsoever for the next 12 months. Or they might say, okay, you've been in a relationship for however many years, there's been no previous incident. We think it's okay for you to have continued contact, but the protection for the wife will be that while you're having contact, you're not allowed to do anything that's considered to be family violence.
Right.
And family violence has a definition, and it includes a really broad range of things that a person is not allowed to do. And that includes things like you're not allowed to harass a person, you're not allowed to intimidate, not allowed to assault or damage property. And so there's a whole heap of things that have been included in this definition of what a person is not allowed to do during that time.
And Christina, in today's environment, does that include social media and emails and text messages and Facebook posts?
Absolutely. So there are orders which relate specifically to how a person's allowed to use social media. Sometimes they say you're not allowed to talk about the person at all on social media or through any electronic means. And so that's really broad if you think about it. So you're not allowed to mention the person or discuss that person via email with another person. You're not allowed to tag them in things on Facebook. You're not allowed to write on their wall on Facebook. But that's only if that condition is included. If that condition is not included, so that specific condition about not talking about them on social media or communicating about them on emails or text message, then what you're not allowed to do is talk about them badly on social media. So you're not allowed to, make bad comments or, say nasty things about them on their wall or to anybody else.
Right. Now, in your example of the wife feeling threatened and the police suggesting either an interim or a permanent order, it sounds like the next step in that is that both of those parties need to show up in a court?
That's right. Both parties would need to go to court, and both then would express their attitude towards the order being made. In some cases where it's a police application, sometimes the wife, for instance, doesn't want the police to be intervening and feels safe around the husband and considers it to be, one incident that is not likely to be repeated. And so they can go to court and say, look, I feel safe going home. I don't need an order in place. The court might override that and say, look, we hear what you're saying, but we still consider it to be appropriate to make an order. In other cases, the person might be supportive of the application and say, yes, look, I think that I'm okay to go home, I'm okay to go home with them, but I would like the protection of an order. It's also the case that the person who the order is being made against, they might either agree to the order being made or they might disagree to the order being made. And depending on which way it goes, the process will then follow a procedure of going through a series of court hearings, which I can explain in a moment.
Yeah, and I was going to say, is this normally a do-it-yourself thing, or are most of these people that for this first court experience, are they assisted or do they have a solicitor or a lawyer involved?
It's always advisable to talk to a lawyer before going to court to do anything, and intervention orders are no different. There are implications and consequences that follow from having intervention orders in place that people just might not be aware of and haven't needed to think about before. So it's always really important to get some legal advice. There are often lawyers that are available at court to speak with that are, community lawyers, and they're from other support networks and agencies, but certainly private law firms such as ours are available to speak with prior to going to court and can be there to represent a person at each of those stages.
Okay, you alluded to talking about the court experience, so please continue.
I might also include at this part the instance where a person is not necessarily going to court because the police have intervened, but if they want to go to court themselves to apply for an intervention order independent of the police.
Yeah, good idea. Thank you.
If a person wants the protection of an intervention order, they can go down to their local courthouse and ask to speak to the court registrar, and they will say that they want to apply for an intervention order. They'll sit down with a member of court staff and they will say, look, I want to apply for an intervention order against my, whoever the person might be. Using the husband-wife example, the wife might go down there and say, I'd like to make an application for an intervention order against my husband. They will then go through a process of explaining what happened. So what is the basis for the person wanting an intervention order? The court staff will help them type out that application and put it into a document, and it will be submitted to the court. Now, because the other person against whom the order is being made isn't at court that day, in fairness to them, they need to be made aware of what's going on. So the application that's being made needs to be given to or served on the other party. Mm-hmm. And there is some time that elapses during those two things. So from the time of making the application to the time that the person needs to come to court for the first hearing, it could be a matter of a week, 2 weeks, 3 weeks. If the person making the application says, look, I can't wait 3 weeks to be protected by an order, I want an order as of today, then they get to go in front of a magistrate on that day and apply for what's called an interim order. So that's an order which essentially is in effect until the court has time to make a final decision.
Okay, so it can be immediate.
It could be immediate, and so that means then that a person will be approached by a police officer very soon after that and handed a document to say, you're being served, which means given, so you're being served an interim intervention order and you have to comply with it. And they'll be given, a document that has all the conditions that they need to then abide by until they attend at court to answer the matter.
Okay, that makes sense.
Really important. Yeah, it's really important for the person at this stage that's received the order to get some legal advice. And that's because quite often there are standard conditions that get included, and they might not realise that there are some, some consequences that might flow on for it, or they might, accidentally be breaching the order without realising. For instance, one of the standard conditions is that a person isn't allowed to be within 200 metres of a particular address. Now, it might be that the only way for you to get to work is to pass down a particular street, and that might be 100 metres from where that person lives. And so you might be just going about your business, but in fact be breaching the order. So it's really important to sit down and think about how could these conditions potentially impact.
Right.
So very important to think about that really, really carefully.
I'm curious. You've obviously been involved in this situation for a number of years and
Yes.
recognized as an authority in the space. How successful are these orders? Do they actually really work? And is it a good system and process, or does it kind of not really meet? Is it not fit to form? And are there challenges here?
Most people are really compliant with intervention orders, and they do serve a purpose. There are some people, however, that because of either personal issues going on in their life or sometimes mental illness that's at play, that intervention orders are not always as effective. But my experience has been that intervention orders are quite effective, and if they are not complied with fully, then there are things that a person can do, that is, report breaches to the police, which results in a person being charged by the police. And so there is a real deterrent to breaching intervention orders. That's not to say that breaches don't occur, because they do, and they're dealt with by the courts, and our office deals with breaches of intervention orders routinely. But they are, as a whole, a system which, in my view, does work quite well. And the system of applying for intervention orders is one which is quite easy and comprehensive to follow.
Great. Christina, we could talk about this all day because I find it a fascinating subject, although I am responding positively to the fact that with your experience, you seem to think that for the most case they're successful, and that's a good thing to hear. If somebody wanted to get in touch with you, Christina or Duke George, what's the best way to do that, and how do they go forward?
The best place to contact us is through our website by Googling Duke and George Defence Lawyers. Otherwise, our phone number is 03-9670-5111.
Great. Thank you for your time today, Christina, and I look forward to talking to you in the future about some other services that you and your firm provide.
Thank you very much. Pleasure to talk to you.